are live, so I started already.
Second was, 6 seconds, it was Stone right. You are right.
You up?
I didn't get to change the, I didn't get to change the agenda because I found out after it was all printed. Like she wasn't that day.
The motion is filed.
No.
Motion is filed. Because he did it the day this morning.
All right, I'd like to call the council meeting to order, please. Our invocation will be led by Dr. Sonny Hatcher, our chaplain for the city.
Let's bow heads. Wonderful God, we thank you, God, for this day, God. We just pause to say thank you, God, for your grace and your mercy, God. God, we pray for each one of the leaders that's represented here tonight. God, we pray, God, you're covering on them, God, as they make decisions on behalf of this city, God. We thank you, God, for the growth of this community, God, even as we get ready to celebrate, God, the opening of the water treatment plant on tomorrow, God. We just ask, God, even though we don't have local elections coming up, God, that you just prepare us, God, for the elections that are coming up in this area, God. And even this week, God, in celebration of Law Enforcement Week, God, we just ask, God, that you cover, God, our law enforcement officers, our police, God, and even the first responders, God, and also watch over our military personnel, God. And we just ask, God, that you, God, allow peace, God, to be the ruling order of the night in this session. And we'll be careful to give your name all the glory, the honor, and the praise. In Jesus' name we pray. Amen.
Amen. Thank you. Chief, you want to pledge allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you.
I'm gonna do roll call now. Councilman Daniel Albertson.
Present.
Councilwoman Elizabeth Craig.
Present.
Councilman Scott Baker.
Present.
Mayor Tony Craig.
Present.
Councilman Claude Lane.
Present.
Councilwoman Jennifer Little.
Present.
All accounted for, Mayor Craig.
Thank
Mhm.
Can we get our bank balances?
Yes. So I was going to mention to you all, you may have seen it in your email this week or in your packet tonight. I included in there kind of a mid-year, 7-month instead of 6, but a mid-year review of bank balances and the changes. So it's not too bad there. I also have ready to provide to y'all a budget update, and I can get that to y'all by email this week. So, but tonight, as of this morning, general, $184,829.61. Sewer operations, $362,271.13. Municipal court, $7,850.54. Corrections, $2,793.33. Cash bond, $876.96. Judicial training fund, $11,644.39. 4 and 5 cent gas, $52,597.25. 7 cent gas, $2,238.12. Rebuild Alabama, $32,968.57. Sewer security deposits, $110,465.10. Sewer tap fees, $62,042.24. Capital savings, $70,559.98 for a grand total of $901,137.22.
Can I get a motion to accept the bank balances in previous meeting minutes? All right, I got a motion from Councilwoman Craig. Can I get a second?
Second.
Second from Councilwoman Little.
Councilman Dan Arvidson,
Yay.
Councilman Scott Baker,
Yay.
Mayor Tony Craig,
Yay.
Councilman Claude Lang. That was unanimous, Mayor.
Alright, so we've got a proclamation.
We do.
Alright, so we've got a proclamation for Emergency Medical Service Week. And I'll read that. Whereas emergency medical services, EMS, are a vital public service providing essential and often life-saving care for those in need 24 hours a day, 7 days a week in the city of Owens Crossroads and surrounding communities. And whereas members of the EMS teams, including emergency medical technicians, paramedics, emergency medical dispatchers, firefighters from entities including the City of Owens Crossroads Fire and Rescue, law enforcement officers, educators, administrators, and other first responders demonstrate unwavering dedication and commitment to safeguarding the health and well-being of our citizens. And whereas these dedicated professionals engage in thousands of hours of specialized training and continuing education to enhance their life-saving skills, often placing them in harm's way to provide critical medical assistance in times of crisis. And whereas access to quality emergency care dramatically improves the survival and recovery rate of those who experience sudden illness or injury, making a profound difference in the lives of our residents and their families. And whereas the 2026 National EMS Week theme is We Care for Everyone, highlighting the inclusive, compassionate, and highly skilled care that EMS professionals provide to every individual in every circumstance. And whereas it is fitting that the City of Owens Crossroads recognizes the value and the accomplishments of all emergency medical service providers, including the personnel of Huntsville Emergency Medical Services, Inc., IMSI, and the members of the Owens Crossroads Fire and Rescue for their tireless service to our community. Now therefore be it resolved that I, Tony Craig, Mayor of the City of Owens Crossroads, do hereby proclaim May 17th through the 23rd as Emergency Medical Services Week in the City of Owens Crossroads. Furthermore, I urge all citizens to observe this week by expressing their gratitude for the dedication and commitment of our EMS professionals and to participate in appropriate programs and activities that recognize the crucial role these heroes play in the safety and health of our community. Let us honor their commitment to caring for everyone every day. Thank you guys for everything you do. Appreciate it.
Chief Swanson, do you want to address that ordinance? Chief Swanson has come in. Do you want to address the ordinance?
Yeah.
Chief Swanson, I try to answer questions during work session, but it's going to be better for you to do so. Do you want a copy of it?
I personally apologize for my tardiness, but we've answered 7 calls since the 2 p.m. hour of the day. So we've been extremely busy. Let me also invite the council members and the mayor. We are going to do an inaugural cookout for our members on May 22nd. Y'all are invited to come by. We're going to do just an old-fashioned barbecue at the station. It'll start at 6 p.m. We would love to have any of you council members. We've invited the police officers that are on duty to come by and celebrate what our outstanding volunteers do for us. So tonight we have for consideration to you basically what this ordinance will do. 26002 will establish the Bureau of Fire Prevention. So about 3 years ago, the city of the mayor and the city of Owens Crossroads created an ordinance that created the fire department, which in turn put in motion where we at today. responded to EMS and fire calls. This is just one of the next steps in building the foundation for the City of Owens Crossroads Fire Department. It creates the Bureau of Fire Prevention to allow us to enforce the fire codes, do inspections. Currently, as it stands, without the adoption of this ordinance, we have to rely on the state fire marshal's office to do those things. And so what this does is just another component to the fire prevention, the fire department, to allow us to do what we need to do. This ordinance is no different than what's in any of the other municipalities that are out there. The city of Huntsville, Mobile, Montgomery, Tuscaloosa, Birmingham, all have an ordinance similar to this that creates the Bureau of Fire Prevention, which then triggers us to be responsible for our inspections and enforcement of the International Fire Code. I will take questions if you have any.
One of the questions that was brought up during the work session had to do with, Chief, I don't remember, something being off the ground.
Oh, yes, the individual fire pits. Is it gonna be, let's say, like somebody, like, you think it needs to be like a certain radius
No. So those
or off the ground fire pits?
So those self-contained little fire pits you can buy at Lowe's and some of the Home Depot, home improvement stores, those don't count. Warming fires at construction sites will still have to have a permit, but what we'll do is basically make sure that it's a contained fire and that it can't spread. There's other regulations out there that trigger the open burn that falls on ADM and forestry. Those are state requirements. We don't enforce those. We would report any violation that violates an ADM or a forestry requirement would go to those agencies. That's a state thing, and we don't enforce state. But
And then another thing was,
cooking.
what are we gonna classify as a fire? Like, and what I mean by that is it gonna be flame fire, or is it gonna be even like smoldering? And the reason why is because, like, you know, like you have somebody that does a construction site or something, and they are a farmer or something, you know, clears out a bunch of land, and they have a large, you know, fire, and they get the permit, then the permit expires, but yet it's still kind of smoldering. Is that gonna qualify, or do they need to?
So the way ADM and the Forestry Commission regulates those types of fires, and again, that's a state rule, so we would have to follow their rules and along with it. So basically, anything over a quarter acre requires a permit from the Alabama Forestry Commission, and then they have a set of guidelines, and it'll be permitted through the Alabama Forestry Commission. Pretty much all open burns somebody has to be present with them at all times, and basically the general rule is you can start them at 8 a.m. and then they have to be out by sunset.
Okay.
Like in our permit application, it explains to the person that's applying, you cannot put anything else on the fire after 3 p.m. is just a general typical rule. What the open burn portion of this does is basically helps us to establish some guidance to keep incidents from occurring. For example, we had a 5-acre field fire that happened back over here off of Sedgwick Drive last year. That was set in very high wind conditions. The fire never should have been lit. And so one of the things that does is it just makes the person that is doing the burning responsible for the burn, and that they understand that they need to take into consideration the weather. Like, I'll give you a good example. When we went under the red flag warning that the State Forestry Commission issued, we ran more fire calls for outside burning for those types of calls. They weren't illegal. It's just that the Forestry Commission said we have low humidity and the potential for high winds, and you should consider not burning during those periods. What our ordinance will do is it will make those types of fires illegal during that period, which is the same as what goes on in the city of Huntsville and other municipalities around us. Basically, this ordinance aligns us with any other municipality out there, is what it sets up. All of those cities have open burn regulations.
So the focus in some of the questions has been on the open burn, but I think at a higher level, there's the Bureau. What other benefits does this end up bringing and pulling together for the city that, as I understand, brings us on par with many other cities that do have fire bureaus. What else does it bring for us?
So by state law, the fire chief is the fire marshal, and the fire chief can appoint a fire marshal to be over that. So basically what that does is we've already got a guy on staff that has all the certifications, actually was a fire investigator and inspector for the city of Huntsville that works with us. And he's already on staff, and he's prepared to go to work doing our inspections and plan reviews and things like that. So what it ultimately does is it allows us that when we have an applicant come into the city, whether it's a subdivision or a commercial building, anything that would fall under the International Fire Code regulations, the Bureau of Fire Prevention would then be responsible for enforcing those. We would look at the sprinkler systems. Right now, our inspector does all of that for us, and then that will fall back to us to make sure that the fire protection systems are up to code. It'll be a collaborative effort between our building inspector and our inspector to make sure that buildings are up to par. For example, we go and inspect. I have been doing them with the state fire marshal because we don't have any power, because we don't have an ordinance in place. And I've been with the state fire marshal to inspect some of the churches and to make sure their fire protection systems are up and running. Basically what it does is things that have not happened in the city will start happening in terms of fire protection where we want to protect the public. And that's what the ultimate goal of the Bureau of Fire Prevention does, is it sets out to set up that one ordinance that helps us protect the public from fire emergencies.
Just so, and effectively increasing proactive.
It's very proactive.
All right, excellent, thank you.
Now, will y'all create a form that y'all use for violations of that to run through the court system? Or does y'all computer system already have something like that in there? Or will y'all, lean on us for us to come write it, or what?
So being that it becomes a violation of law, it would then become a law enforcement matter. We would have to work in collaboration with the law enforcement side, because when you issue this citation, my assumption, again, I just stated the Holiday Inn last night, so I'm not a lawyer. But, my assumption is, and correct me, gentlemen, if I'm wrong, is that because it is a violation of ordinance, then it would fall back on y'all to do the citation, and it would go before a magistrate.
Okay.
But some of these things in here carry jail time
Right.
and a fine, make a $500 fine, up to 30 days jail time. So for violations, so it just puts the penalties there to make sure that we're staying in good faith with our ordinance. Right. And some of the other things you'll notice it's already there. We already have a Knox box ordinance that's already been adopted by the city. It just reinforces that exists. It also reinforces the fact that you cannot obstruct hydrants. For example, when the plans review comes in for a subdivision, one of the things we'll look at is that there's adequate egress based on the number of homes that are being built, and that the fire hydrants are of appropriate distance and being installed to code. So that would be just some of the things that we would do, as well as just the businesses that we would inspect to make sure that their fire protection systems were up to date. We just recently did an Airbnb that has applied for a business license in our city. We appreciate your consideration on this ordinance. And if you have any questions afterwards, please don't hesitate to email me, and I will do my best to answer those questions for you.
Thank you.
Right. Any more questions about this ordinance? Any more clarification concerning this ordinance? Can I get a motion to consider ordinance number 26-002?
Motion to consider.
Got a motion to consider from Councilman Arvinson. Do I have a second?
Second.
Second from Councilwoman Craig.
Councilman Scott Baker,
Yay.
Mayor Tony Craig,
Yay.
Councilman Claude Lang,
Yay.
Councilwoman Jennifer Little.
Okay,
All right, can I get a motion to adopt ordinance number 26-002?
Motion to adopt.
A motion to adopt from Councilman Arvidsson. Can I get a second?
Second.
Second from Ms. Little, Councilwoman Little.
Councilwoman Elizabeth Craig. Councilman Scott Baker.
Yay.
Mayor Tony Craig.
Yay.
Councilman Claude Lane.
Yay.
Adopted unanimously, Mayor.
Good deal. Thank you, Bruce. Thank you, David.
Thank you.
Appreciate it, David. All right, what's next on there?
Resolution 26-009, a resolution authorizing the city to enter into an agreement with Andrews Technology for web-based time and attendance services.
Got any questions or comments for this resolution? Here's the question I've got. What do we pay for our current timekeeping system?
We pay about $200 a month, plus an annual fee of, I think, $25. And then this is a annual fee. It doesn't have a monthly, I don't believe. So the city is authorized to expend the $59.95.
Right.
And it won't be as much next year, because it's the implementation.
So we're spending about 5,000 a year now.
So it's about the same.
Yeah.
But these people already have contracts that work with BSNA software, so they've already know, and the other company that weren't interested in trying to develop a connection with them. So, also, Bruce, didn't you say Huntsville and other communities, you know, of use the Andrews UKG?
Yes, ma'am. The city of Huntsville uses it, Huntsville Hospital uses it, and I believe, the Bowman Corporation uses it as well. Madison County does too. It's a very
Okay.
popular program.
So it sounds like it's pretty reliable, since those people are all using it. Who knows? All we can do is hope.
Any other questions or comments? Can I get a motion to adopt resolution number 26-009? Motion to adopt resolution 26-009. Can I get a second? I got a motion from Councilman Baker, what about a second? Second from Councilwoman Craig.
Councilman Dan Arvidsson.
Yay.
Mayor Tony Craig.
Yay.
Councilman Claude Lane.
Yay.
Councilwoman Jennifer Little.
Yay.
That was unanimous. Okay. Resolution 26-011 is the Municipal Water Pollution Prevention Program Annual Report. This is a report that ADEM requires of us, and no funds go with it. It's just a report of all the different readings that happen with the wastewater treatment plant, and the people who monitor our plant are the ones that produce this report for us. So it's due by the end of the month.
Okay. Can I get a motion to adopt resolution 26-011?
Make a motion to adopt resolution 26-011.
Second. You got a motion, Councilman Lane, second from Councilman Baker.
All right. Councilman Dan Arvidsson.
Yay.
Councilwoman Elizabeth Craig.
Yay.
Mayor Tony Craig.
Yay.
Councilwoman Jennifer Little.
Yay.
I think that one was also unanimous, and that,
All right, so can we get an update on pathways, please?
Evening, council, Mr. Mayor. Be remiss if I didn't remark about Chief, the terminology, rapid oxidation process. I believe that was the definition we were looking for earlier as it relates to a fire. That is the International Fire Code. I believe that's how it is defined. So if there was any question earlier, rapid oxidation process. That is how Owens Crossroads in that particular ordinance is going to define a fire. So, good evening. Just want to bring the council, mayor, and also residents of the community kind of up to speed where we are with pathways litigation. All of these matters are available, publicly accessible on the Alicourt. There was initial pleadings on behalf of the city seeking to close the pathways for being a nuisance purposes under a particular statute. Pathways filed a responsive pleading and also a counterclaim. We filed a answer to that action. It was assigned to Circuit Judge Comer. There's a standing order in the 23rd Judicial Circuit that I guess requires, I don't know the specific terminology, I'd have to look at it again. There's a standing order that any civil litigation has to be considered for mediation and X number of days in advance of a trial setting. And that was something a presiding judge decided here in Madison County a while back. Hey, let's see how many things we can get resolved or settled without need for a jury trial.
And so essentially in that, basically what happens is any civil case that gets filed, an order is going to be entered in that case of referral to mediation, but that happens in every single case. So
yeah, that is in every action that has a CV style case number, that order is entered. We've been in the process with opposing counsel for what the rules of civil procedure provide is essentially the discovery process. There's requests for production of documents and interrogatories, which are essentially just answers under oath. And it's a way for both sides to more fully develop their case, but also have the information needed to proceed with a trial setting. One of the things I did want to bring to y'all's attention this evening is in March, there was a joint motion filed by the city and Pathways seeking protective order because of the nature of the facility and the calls for services, since, there potentially would be a chance for incident offense reports, narratives, things that speak to NPPI, non-public private information. Both sides agreed, hey, let's let's file a joint motion asking for the court to enter a protective order. That was an order, I believe, was put in place March the 30th by Judge Comer, adopting that joint motion or accepting that joint motion and granting it. On May the 4th, so kind of where it stands from discovery, the city has offered discovery, has answered interrogatories, and has produced certain documents and the request for production that were asked by Pathways. And that was undertaken, but it is a continuing obligation for each side. So we're still in the process of, once something is received, if we get something that needs to be supplemented, we both sides have to do that. End of last week, and Tom, correct me if I'm timeline's off, but end of last week, there is a time frame provided by the rules of civil procedure, when these things have to be turned over. Once a request for interrogatories and request for production documents is filed, and Pathways did fulfill their obligations under our request for production, and we did receive those, and we're currently in the process of reviewing what has been turned over in the course and scope of discovery. We anticipate within the next 7 days getting over to them some additional discovery responses, and that is because on the May 4th date, there's an order entered on May 4th based on another joint motion filed by the parties that was a protective order, but it related with specificity to certain records that relate to minors. Pathways is a facility that's licensed by DHR, and so in the course and scope of the discovery process, our office reached out to Madison County District Attorney's Office, who would be the entity that would prosecute certain actions which we're alleging are the basis of our nuisance action. And there's a specific statute that talks about juvenile records. So Tom and I did some research and reached out to opposing counsel, and we all agreed that there was some specific case law that provided exceptions and protections so we can ensure that even in the process of discovery or if there was incidental disclosure, how that could be clawed back, just basically ways to do it proper. So Judge Comer entered an order May the 4th, I believe, was the date that he entered that order. So last week. So kind of where we stand, what we anticipate going forward. Within the next week, we should have the discovery process fulfilled, both sides having turned things over. Now, what will happen, and this happens in every case, is there'll be a question asked during a deposition that will lead to additional requests for production, that kind of stuff. It's a living thing. As we move forward, we may be sought, they may seek for us to produce some things and vice versa. But to kind of answer the questions that were asked in the work session, or a question that was asked in the work session, kind of timeline. We anticipate discovery being done to the point where we can schedule depositions within the week. We feel both sides will have turned stuff over, and with that, both sides will have a discussion about, okay, let's schedule depositions. Tom and I have spoken with opposing counsel on multiple occasions, and I think everybody's in agreement that we can do it essentially with Ms. Easton's schedule, whatever accommodates her. Thankfully, Counsel for Pathways, they have an office here in Huntsville, and we've all kind of settled on we're going to do depositions there. But we're also trying to make sure that we can be efficient in our use of city employees' time. And so our hope is to get as much accomplished through the production of records and answering of interrogatories to limit the course or the scope of depositions. So kind of what will happen next is depositions will occur. And once that happens, we will have to make a decision as it relates to mediation. And that'll be, obviously something that our office, we represent the city, but we can't make the decision about that. We have to, once depositions are concluded, we can more fully inform kind of our standing. The city can direct us to apprise the other side that we wish to engage in mediation, or the city can say that, there's not going to be any further.
I don't believe it's going to be productive.
It's a misallocation of resources and time to engage in mediation. If the city feels that way, we would communicate that to opposing counsel. And then what normally occurs if mediation is not going to bear fruit, that is, the court is made aware through a joint filing, hey, Your Honor, this matter is not going to get resolved through mediation. Please set us, for trial next available date. So, our kind of timeline, that's where we are. But I'd be happy to answer any questions any council member or mayor may have, to the extent that is permissible in the course of litigation. Try to carefully couch my answers. So,
for the mediation, what other dependencies are there besides the depositions and any of the documentation that has been provided?
Let me make sure I understand your question. What is next? What could be out there?
What is required to be completed? So a dependency in order to.
Well, I don't understand your question. What is required with the?
You don't have to do anything to that. I mean, you could do there's not like a checklist of things that need to be done.
Oh, I had understood that depositions need to happen before there's a determination with regard to mediation from what you just said.
No, I think before decisions are made, it would be.
We believe it would be better to kind of have all that stuff done. So we
correct. Yeah, I mean, to better see, to just make a decision as it relates to mediation without having exchanged discovery, exchanged documents, answered interrogatories, and deposed parties. I don't think the city can make an informed decision as to whether that mediation could bear fruit.
No, and I understand that. I guess my question is, before the determination with regard to mediation, what is required? And it sounds like deposition.
Now, are you asking from like a rules of civil procedure, or are you asking just like?
I'm asking maybe from layman's terms, like when it comes to mediation.
The parties could arrive at a desire. The parties could achieve a decision at any point. I mean, hey, let's do mediation. What I would respectfully offer at this point in time, we filed an action on behalf of the city for there to be a finding that business is a nuisance and should be shut down. They respectfully disagree. So there's not enough wiggle there. So in the traditional sense, like I think the best way I can answer that question would be to couch it in a response in like family law. You know, he wants a divorce, she wants a divorce, sitting down.
Because that same order of referral gets done in divorce case.
Yeah, and so what could happen in this divorce action, you know, John could say, well, all that's important to me is my vote, right? And, you know, Susie could say, well, if I get the car, we're great. Well, there's no need for mediation. But if it is, the parties are close and maybe they just need an independent party to go, well, if you give a little here, maybe you can get together. That's when it actually is fruitful. I mean, I don't think I'm speaking out of turn saying what the city is alleging in our action and what the position of the defendant is the chasm is so vast at this point, mediation is not going to be beneficial or in any way bear fruit. So,
Okay.
but
and the judge can't end up saying, I understand that you guys are of that opinion. I would like you to still sit down.
I mean, no, the judge can say you have to do it.
I would think that the inherent
call.
Yeah, I would think the inherent authority of a circuit judge, he could compel the parties to attend mediation. I feel very comfortable saying that is within his honor's purview. I don't believe I've ever seen where it has been compelled outside of the domestic relations case. Outside of family law, I don't know of any instance where you have to attend, you know, because if both sides are coming to the court saying, Judge, we're so far apart, this just needs to be litigated and somebody make a decision. You know, again, I would not be goofy enough to think I could speak to how his honor would rule, but I don't anticipate that the court will make a finding to compel the parties to mediation. There is an order compelling us to consider mediation and to undertake mediation, if, you know, but I think if we went back to the court and said, Your Honor, the chasm's too vast, that he would understand. I mean, that happens, you know, in car wreck cases and stuff like that, you know, you're ordered to do mediation. Well, you know, Judge, my claim is for $1 million. He's saying he's not responsible. You're not going to achieve a result in mediation. But I think your question is an interesting one, because I think under the inherent contempt powers, I think Judge could compel the parties to undertake mediation. I just think it wouldn't be in the interest of judicial economy for him, his honor.
From an efficiency perspective, it's not.
If the chasm is too vast, hey, Your Honor, we're not gonna. All we're gonna do is pad the pocketbook of some mediator and show up and go, nope, we're agreeing to disagree. So
Unless he wants to borrow the boat, use it for a week, and then tell you to go to mediation.
Tom and if there was a court reporter here, I would make sure to carefully reflect. Tom and I don't do family law for a reason. That's how you end up getting shot. You know.
Another question back to the working session. I think from a perspective of milestones, it'd be excellent to see some type of schedule. And as I mentioned before, it's a living document, but you know, when is X expected to be completed, and then when do we plan to do like depositions? And then from there, once the depositions are done, when are they required to be submitted, and then what's the review time?
So his honor has entered an order setting us for trial in 2027 at some point.
2027 seems far out.
But just that's his honor. When a lawsuit is filed, an order is entered, you know, it's given a date.
No, I understand. I'm struck by the 2027, but also not seeing that that's efficient.
No, I don't, you know, please don't take me offering a fact that's in a court's order as me saying that that's going to be what occurs. Yeah, I mean, I would.
But you take it as me saying, well, we get this actioning happening sooner, which I believe that you guys are working toward.
Yeah, I think as far as timeline, like I said, we feel very confident within, you know, a week that discovery will be completed, and then it would be scheduling depositions. This is highest priority for us and for council for Pathways. And the reason for it is, thankfully, and I'll say this in the open, we've been working with Attorney Hall, and he is very reasonable in his scheduling, in our conversations about discovery, phone calls that we've had about depositions. This is in the forefront, because his client, what our lawsuit is seeking to do is, close their business.
Yep.
So, it's highest priorities. What I would expect is, we would ask, once discovery is complete, within a month, to have depositions, because this isn't something, I think I probably should say this. The court's not involved in depositions. This is not something where we have to proffer those transcripts. This is the parties getting together and deciding. Shoot, you can have a deposition on a Saturday. You just have a court reporter, get somebody sworn in, and questions are asked. The turnaround time for a deposition transcript, a week or two. And then I really think it would be asking the other side, where are we? And then as far as scheduling goes, it would be approaching Judge Comer and saying, Your Honor, kind of in the 23rd, they have civil weeks, they have criminal weeks, they have family law weeks. Hey, Judge, when's, and then that's us and the other side sitting down going, okay, if this is going to be a trial setting, how long do we think it would last? And then, kind of arrive at a number. Hey, Your Honor, what's the next date you have available for a civil trial that's going to take a day and a half? And
So let me go back to the question with regard to milestones. Is it possible to put together
no,
a
sir.
document that
No,
says?
sir. No, it's absolutely not. No, sir. No, we can't produce anything.
Well, even if there aren't any dates on it, so that we know what is the type of.
We will
things that-
continue to inform the city council when important milestones are met. And the reason I say that is, there's, if we should not produce a appropriate response to discovery request, the other side could file a motion to compel, within 14 days, turn these things over, penalty of, punishment of contempt. I think it would be improper for us to reduce to writing, we expect this to occur on this date, because again, I
Every
think,
case is different.
yeah,
And I understand that, and again, I'm trying to look toward what's the next step, and it seems like we are kind of informed that the next step is this, but we don't see what the following 5, 6 steps are, right? And I guess what I'm looking for is, I just don't want to know what the next step is. I'd like to know what the next 4, 5 steps are.
discovery.
Again, I'm not expecting that you put a name to it, but
Discovery, depositions, decisions about mediation, calendaring with the court, and then a trial. That's the next steps. I don't know how to more fully develop that, because the rules of civil procedure provide timelines for certain things, and it could be hey, gosh, I think for interrogatories, within 30 days or something, there's these time frames, and you go, hey, these are juvenile records. We need to get an order in to protect these. And so there's a joint motion that was prepared.
Well, and we're at the mercy of the court. He goes to scheduling, and there may be something that's more important that gets in front of it. It's
right,
up
again, I'm
to
not
the
so
courts.
focused on dates, but I am focused on what are the next steps.
It depends.
I think discovery, depositions, decision about mediation, calendaring with the court, and then trial. I think that from a 30,000 foot view, kind of what's still outstanding.
That's the minimum basics.
Yeah, and I think to say, gosh, I'm trying to think the best way to describe this. What industry are you in? Forgive me.
IT.
I see. Okay. So like where are we from an IT standpoint? The servers have been placed in the building, the wires are plugged in, and right now we've got the IT team and they're making a decision about, hey, is this server deck functioning properly? And can we turn it over to the team for it to go to the desk? I think that's where we are.
And I understand that,
Yeah.
and, you know, I do come from a project mindset. So if I came across about dates a little too strongly, I'm not so much looking dates, but when I develop a project plan, it has dates, right? There's a point at which we need to have it complete because we're delivering it to a customer.
And there's a reason why I try to strike every engineer on the jury.
Yeah, I understand that, I get that, yeah.
All right, thank you, Matt.
Yeah, but I do think, in all seriousness, with the analogy with the servers and stuff.
Yep.
We have a server room, power's running to it, the deck is in, stuff's plugged in, and the team is going out to sit at the individual desk to see if the router's working. And if the router is working, well, then we can go to the boss and say, hey, when do you want to sit down and have a conversation with the team about
What gets installed.
what gets installed?
Yeah.
And then once that decision is made, we can go, okay, for sure, we're gonna have, everybody sitting at their desk operating the machines on this date. I do think that the question that's before the court is fairly streamlined. I mean, obviously, the other side and their counterclaim put more to it. Our position is, hey, y'all are a nuisance. We want to close it. We want it to be closed. Pretty straightforward. And I think that we're going to go to court with, Judge, this isn't something that's going to take a lot of the court's time. And can we have a quick date? And I think, I'm not going to speak for Attorney Hall, but I think he would agree that this is something that wouldn't take up a ton of the court's time, and both sides would be asking for the court to give us, the soonest available. So
maybe we could get it in 2026 instead of 27.
yeah, I will tell you this: I would love nothing more than to be talking to you guys about rapid oxidation process versus pathways, but before Halloween. Nothing would make me happier, because I think Ms. Easton would quit getting so many phone calls from people, in the news, and we would love to have the community have a better understanding of what's going to happen on Hamer Road. So, but we will continue, and I think probably in the next, with Discovery, Tom, correct me if you feel differently. I think with Discovery, this is second week in May. We're going to know in May kind of how it's going to flow. And the reason I say that is we're going to know in May when we're going to have depositions, and depositions may occur in May, I think once depositions happen, we would be able to actually come with more definitive dates. So.
Well, I appreciate your efforts.
Yeah, no, I will say it's been very good working with Ms. Eason, because there are things where we have to call and say, look, we've got these interrogatories, we need to get your answers, and she's been gracious enough to come to our office, let us run by her house, and so I mean, this is not something where Ms. Eason is she's putting the effort in, and a seamless transition. I want to point out, because I don't think it has been noted, Ms. Eason was earned the MNC.
Hold on.
Okay.
Hold on.
I can't embarrass her, Mr. Mayor.
I was gonna do that.
Well, then I'll sit down. All right, I'll sit down then. I think it's appropriate. But if there are any additional questions, obviously subject to open meetings and pending litigation. But if there's anything that I can answer before the meeting ends, let me know, and I'll be happy to come back up.
Real quick, I appreciate what Dan's trying to get information on, because it's nice for us to know. I understand it's a complex issue to kind of answer, but also we have residents that sometimes ask us questions.
Yeah.
And I know we can't go into details, but to have some sort of idea of.
What I would suggest, I'm Councilwoman Little, I'm glad you said that. And I would say, no, I would say they would get the same response every time, which is this ongoing litigation. I certainly appreciate your phone call. We'll let you know if you can. Or give them Tom's cell.
That's part of the reason we wanted to address.
That's why we're here tonight, and it's not lost upon us. We litigate this stuff. You guys are elected officials that have to answer to constituents, and it is not easy going, well, the lawyers say that we can't say. I mean, I get that, you know. What I would suggest, and this is, I think appropriately styled as legal advice. It is ongoing litigation, but what you could communicate to your constituents is that the process related to discovery. And so when they go, what is discovery? That is each side presenting paperwork to each other, each side answering questions under notary seal, trying to streamline the litigation. And then depositions, that's where we are. And so we will, as soon as all that stuff is set, and I do think it would be proper, as soon as depositions are set and that kind of stuff, we will come back to that council session and go, hey, just so that it's heard by community members who may be watching on Facebook or whatever, YouTube, we'll make sure that that's there. So, thank you.
Thank you.
Thank you.
But if you do want to give your, constituents Tom's cell phone, I'm comfortable with that too.
All right, so I'd like to recognize Christy because she has worked very hard and she's earned which isn't given out very lightly and taken very lightly, prestigious Master Municipal Clerk designation. And the Master Municipal Clerk is the highest level of achievement on the municipal clerk profession. Christy had previously earned her Certified Municipal Clerk designation in 2023. And believe it or not, she's believed to be the first city clerk in Owens Crossroads history to earn the Master Municipal Clerk designation. The program requires hundreds of hours of advanced education, leadership training, and professional public service. The knowledge Christy has gained through this certification will help strengthen the city's operations and service to our citizens, keeping us in line, for sure. She is currently pursuing certifications in human resources and local government professional management. Please join us in congratulating Christy on this outstanding accomplishment.
For supporting me and encouraging me to do that.
Well, and I appreciate that because when people think of City of Owens Crossroads, I don't want them to think of us as just some small little city. We don't, we do things the back roads way, so to speak, but it's nice to have you and all the knowledge that you have in certification that you have, so we can kind of, I don't want to say compare, but stand up against other cities. So I appreciate that, because I know you do a lot of work into it.
But along with that, we have these other two that.
That's right. They sure do.
But I agree along those lines in that, just like, the fire bureau, all the certifications now, they can apply what they know within that scope. We already have it with Chief Owens and his staff, but they are able to bring in their certifications and so.
Glad to set the example.
So every clerk is continually doing education and learning and reaching certifications, renewing certifications. Laura has her CMC, Teresa has her Alabama Municipal Revenue Officer, and she's also a magistrate. And we're all working towards that. Brandy has certifications as well, so it's not something that's just me, it's just a different type of certification.
Well, good.
And it takes the whole team to make it run.
Nicely done.
It does.
It really does.
Yeah.
We have to have each other. I think we all feel that way. If one of us is missing, we're like, ooh, so we have to have each other.
We've got a good team here with everybody involved, excluding LT, but we're good.
I get no respect.
All right, can I get a motion?
Motion to adjourn.
Got a motion adjourned by Councilwoman Little, second by Councilman Lane.
Councilman Dan Arvidson,
Yay.
Councilwoman Elizabeth Craig.
Yay.
Councilman Scott Baker,
Yay.
Mayor Tony Craig.
Yay.
Councilman Claude Lang.
I say.
Oh, I'm sorry. There you go, Mayor.
I'll help you out. I know you got a lot on your plate.
Thank you. It's unanimous.
Thank you all for coming, and thank you for what you did.
I'm sorry, what?